In this lesson, we're going to talk about TILA, the Truth in Lending Act, and RESPA, the Real Estate Settlement and Procedures Act. So first of all, the Truth in Lending Act, also known as Regulation Z. So when you see Truth in Lending, also think Regulation Z. They're one and the same. So the Truth in Lending Act is actually a consumer law that was passed way back when in the 1970s. It doesn't just apply to real estate, but to all sorts of consumer loans like credit cards and car loans and other types of loans, plus real estate loans. And what the requirement of the Truth in Lending Act, the main requirement is to disclose the annual percentage rate, we'll talk about that in a minute, and all of the finance charges. You know, you probably sometimes get credit card solicitations in the mail, and on the outside of the envelope it says 5% APR or 0% APR or something to that effect. Well, the APR, the annual percentage rate, is basically the bottom line, if you would, of what your true interest rate is. Because sometimes, as you know, in a real estate loan, there's an interest rate quoted, there's closing costs, there's discount points, there's a loan origination fee. So you as the borrower are not just paying the interest on the loan, but you're paying all these other finance charges, and they all boil down to what's called an APR, an annual percentage rate, which reflects the true interest rate. And almost always, the interest rate on the face of your note, remember the face rate or nominal rate or the contract rate? Let's say the note calls for 4.5%. But because of the fact you're paying some discount points and you're paying some other charges for the loan, your actual true reflective interest rate may be not 4.5, but 4 3/4 or even higher sometimes. Now, the Truth in Lending Act does not apply to all properties. It certainly does not apply to commercial properties. But basically what you want to remember is it applies to owner-occupied 1 to 4 family residences. So technically it doesn't apply to investment properties, but what you will see is on any 1 to 4 family property that's financed, whether it's an investment property or owner-occupied, the lenders are going to follow the guidelines under Truth in Lending. Now, it applies to institutional lenders only. What do I mean by that? Well, what I mean is it applies to FHA, VA, all conventional loans, or any loan that's placed by a lending institution, whether it's a credit union, a bank, a savings institution, a mortgage company, etc. What it doesn't apply to is seller carryback financing, nor does it apply to loan assumptions, but it does apply to any institutional loan. And sometimes when mortgage companies and real estate companies advertise property, in their ads they may go a little bit further than they should and use what are called trigger terms in their advertising. All right, and these trigger terms, again, do not apply to loan assumptions. Why? Because a loan assumption is not an existing loan, or is an existing loan. It's not a brand new loan. So what are these trigger terms? If a lender or if a real estate company uses in their ad the down payment, states what the number of payments are, 360 easy payments, what the payment amount is of $800 a month, the payment period, in other words, monthly or quarterly payments, or states finance charges such as discount points. They say, get your loan here, only 2 points. Any one of those in the ad is considered to be a trigger term. And if the ad has a trigger term in it, then full disclosure must be made. Now, advertising the APR alone is not considered a trigger term. So if all you advertise is the annual percentage rate, that's not a trigger term, and that would not trigger the disclosures that we'll see in the next slide. So if a lender advertises or a real estate company advertises using trigger terms, then the ad has to include the entire loan amount, the down payment amount, the number, the amount of, and the frequency of the payments, the total amount, the total dollars paid in all the payments, plus the APR. You know, where you're probably most familiar with this is on car ads, where if you watch the car ad on TV, often, and they talk about financing, oftentimes right at the very bottom of the ad. You can hardly see it. All right, there's this disclosure information. Same thing is true on a radio ad for a car. They advertise the whatever cars they're advertising, and then the person on there, blah, 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 APR or whatever they say. Who knows what they're saying because you can't understand them. But what they're doing there is they're trying to comply with the Truth in Lending Act and disclosure under that Truth in Lending Act. Last thing here on Truth in Lending. You know, in most instances, there are no rights to rescind. Certainly, if you get a loan on a property to buy that home, there's no right to rescind. But on a refinance, again, only on a refinance of someone's personal residence, what does that mean? Where you live, there is a 3-day right to rescind the loan. So if you're refinancing your home, from the time that you sign the closing documents, you still have to be given 3 days, during which time you can go home and sleep on it, and if you decide you don't want the loan, you can then back out. Once the 3-day period goes by, you sign off that you've agreed to go ahead, and the loan then is permanent on your property. The next law we want to talk about is RESPA, the Real Estate Settlement and Procedures Act. And this is specific to real estate, as the name implies. And it refers to settlement, meaning closing. Here in Arizona, we use the term closing much more frequently than settlement, but around the country, the word settlement refers to the closing of the transaction. And this came about in the early 1970s, largely because of the fact borrowers were not being given full disclosure relative to all of the closing costs. You might have a veteran who visualizes a no money down loan, and yes, there's no down payment, but by the time they get to closing, there's $1,000 or $2,000 worth of closing costs that may not have been disclosed to them. So RESPA was originally designed to make sure that borrowers get full disclosure relative to their closing costs in a real estate transaction. And since then, it actually has been expanded to cover more than just closing costs. So what does it require? First of all, as mentioned, disclosure of settlement costs or closing costs. In order to do this, the borrower must be given a loan estimate within 3 days of loan application. So if you or one of your borrowers goes in to get a loan on property and you fill out a loan application, then that lender has to give you a loan estimate specified by law within 3 days of making that application. Now what typically happens is you're given that documentation right away when you make the loan application, whether you do it in person at a lender's office or whether you do it online. RESPA also requires that the borrower be given what's called a closing cost booklet. This is referred to as your home loan toolkit currently, and this is issued by the CFPB. The CFPB is an agency of the federal government, stands for Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau oversees the RESPA, and one of the things that they require is that this closing cost booklet, which is a detailed explanation of a lot of the costs in closing a real estate loan, be given to the borrower, either physically or again online. Another thing that RESPA requires is that the borrower receive a closing disclosure. This closing disclosure gives the borrower a breakdown of all of the costs and allows the borrower to compare the total loan at closing to what the loan estimate was when they first made application. And if there are major discrepancies, the borrower does not have to go through with the loan. This closing disclosure has to be given to the borrower at least 3 days before the closing. So the borrower has time to review it and make a decision as to whether or not they are going to proceed. And again, it's the lender's duty to make sure that basically the terms of the loan have not changed substantially from the time the loan estimate was given at loan application to the time of closing. Now, RESPA applies to 1 to 4 family properties, similar to Truth in Lending Act, and it applies to what we refer to as federally related loans. Again, those would be FHA, VA loans, as well as conventional loans, because every lender that makes conventional loans pretty much has either FDIC insurance, federal deposit insurance, or some other type of federal insurance. So basically any loan made by a lending institution or a mortgage banker or mortgage broker is really a federally related loan. There are some exceptions, of course, but what you want to remember is RESPA applies to federally related loans. There are exemptions for seller carryback loans and loan assumptions. So basically, RESPA does not apply to these types of loans. Now, some other things that RESPA does. RESPA is the law that also limits the amount of dollars that can be held in an escrow account. Remember we talked about a budget loan where the payments are made PITI and the taxes and the insurance go into this impound account or escrow account? Well, the federal law, RESPA, is the law that limits how much a lender can hold in that escrow account. It also requires the lender to give the borrower an accounting of the escrow account once a year, and if there is more money in there than is allowed under law, that money has to be refunded in some way to the borrower. Of course, if there's not enough money, then the borrower's payment could be increased, or the borrower could actually have to write a check to put enough money into that escrow account. RESPA also requires that lenders and real estate companies disclose what are called affiliated business arrangements. For example, let's say a real estate company also owns a mortgage company and a title insurance company. And the real estate company, of course, wants to refer business to that mortgage company or title company. This is called an affiliated business relationship. And under the law, that relationship has to be disclosed. An estimate of the cost have to be given to the borrower, what the cost would be to use that company. And then finally, it must be disclosed to that potential borrower that they do not have to, they cannot be required to use that affiliated business company. Also important to note that real estate licensees, by referring business to this affiliated company, cannot receive any compensation for that referral. RESPA also prohibits any kickbacks, referral fees, or unearned fees where a real estate agent might refer business to a settlement service provider. So what do we mean by a settlement service provider? Well, that could be a mortgage company, a title company, an escrow company, a home inspection company, an appraiser, a number of others. So let's take a scenario where a home inspector comes to you as a real estate agent and says, for every home inspection you refer to me, I'm going to give you $50. Since RESPA says that no kickbacks or unearned fees can be made to or from a settlement service provider, it would be illegal both for that home inspection company to pay you and for you to accept it. So if you're going to refer business to a mortgage company, a title company, and so on, you should be referring them that business because you know that they give your client the best possible service. It would be illegal for that mortgage company to pay you any kind of referral fee. It would be illegal for you to accept any kind of referral fee. Also under RESPA, the seller cannot require the buyer or the borrower to use a specific title insurance company. This is kind of a little-known aspect of RESPA, and it's kind of confusing. It says that the seller cannot require the buyer to use a specific title company, but a title company and escrow companies are different. I'm not going to go into this in great detail, but just remember for the purpose of the test that the seller on a federally related loan, where the borrower is getting a federally related loan, cannot require the buyer to use a specific title insurance company. So that's our discussion on truth in lending and RESPA.